OTF Vonni is all over the internet right now because he had a court appearance on the 4th, which was, for me, it was yesterday, right? And people are saying that he got a protective order and that he's in PC, and this means that he's cooperating, aka snitching, right? Even Hood Educated dropped the video saying that this means that he is snitching, that he's cooperating, he's talking with the feds, right? Me, on the other hand, I'm not 100% sold on it yet. I got the paperwork. I've read through it. I'm not 100% sold that he's talking. I'm going to get to that and explain my side in a minute, but I'm going to let Hood Educated go first. But before we get to that, y'all know what I need y'all to do. I need y'all to go down and hit that like button. Make sure this video gets out into the YouTube algorithm, because this is going everywhere. Everybody's spreading this narrative around that he's talking, and I don't think so yet. There's only a few of us out here that's saying, no, wait, hold on. Let's look through all the paperwork first. You know what I mean? And I'm with them. Let's look through all the paperwork. I've looked through all of it. All right? So make sure you guys hit that like button. Get this video out into the YouTube algorithm. Let's get some eyes on it. If you're new to the channel, go ahead and hit that subscribe button. Make sure you hit the bell icon. That way YouTube notifies you every time I drop a new video. Come on, man. We got that fire over here. Let's go ahead and listen to what Hood Educator had to say about this.
On Tuesday, December 3rd, Durk's co-defendant, Kevon London Grant, aka Cuz, filed a motion in federal court to protect potentially dangerous case evidence. Grant's legal team requested a protective order, citing concerns that unregulated access to sensitive information can put witnesses, victims, defendants, and those prepared to testify at serious risk. This case involves significant safety concerns regarding disclosure of names and personal identifying information of victims, witnesses, and defendants, Grant's attorney Peter C. Swartz explained. Among the evidence at issue are graphic crime scene photographs, autopsy reports, and statements from protected witnesses, which prosecutors say could lead to retaliation or intimidation if improperly disclosed. I know when Lil Durk had seen that his homeboy had filed a protective order, and when his lawyers came to him and said, hey, you know, your co-defendant here, Lil Cuz, is finna file a protective order, I knew he probably asked his attorneys, what is that? I mean, you know, we from the hood.
Well, see here again, he's saying that Vonni filed the protective order. That's not the case. The government filed the protective order.
Understand what protective custody is, but we never heard of this protective order thing. Like right, why is my co-defendant
it's a difference between a protective order and protective custody.
Filing a protective order. And when his lawyers explained it to him, man, when his lawyers explained to him what a protective order is, I'm talking about, man, that right there probably had to have been one of the worst feelings that Lil Durk probably ever felt in his life. I'm talking about that right there was just, you know, one of them body blows. Because we got to understand something. For those of you who don't know what a protective order is, like he said in the demonstration that I just read, y'all, a protective order is to protect evidence. A protective order is to protect witnesses, victims, and anybody that got anything to do with the case, right?
He's right on this
Even
part.
tangible and material evidence, right? But as long as I've been living on the earth, I have never seen a defense attorney file a protective order.
It's not the defense attorney filing it. It's the government.
are always seen, prosecuting attorneys, file protective orders and stuff like that because they want to protect the integrity of the evidence, and they want to protect their witnesses. They want to protect their victims. So I've seen prosecutors file these protective orders.
Listen, honestly, I fuck with Hood Educated. I do, for real. He covers a lot of stuff though. So yeah, there's gonna be times where he's gonna get stuff wrong. And guess what? I'm gonna be here to call him out on it. Because that's what I do, right? There's nothing wrong with that. I have nothing against the man, but you heard what he said. He's never heard of defense attorneys filing for this protective order. Well, guess what? It's not the defense attorneys filing for it. I don't know if he actually read the paperwork himself. And that's what I'm saying. He covers so much stuff. He probably has a team that helps him, right? Sometimes they're inaccurate. And I do have the paperwork. I will pull the paperwork up to show you guys what it's actually saying.
Never seen a lawyer do it. First time in history, right?
This Henny hitting, bro.
And so we got to ask the question why, because we hood educated, not lane related. We always asking why, what's going on. Let me explain to y'all what I believe that is going on. Here it is, we got Lil Cuz, right? Lil Cuz is caught up on the murder. Let's just say Lil Cuz becomes a witness for the federal prosecution. Now Lil Cuz is a witness to the case. Why? Because he was there. He dealt with, I'm talking about everybody that's involved with the case. He has great detail about what happened. Lil Cuz is in the federal jail now. He understands that the disciples is in there running together. And
all right, I mean, they're in California jail. Are there a lot of disciples in California? I know I got a lot of viewers from the West Coast. I'm from Ohio. Y'all let me know. Are there a lot of disciples in California, in the LA area? I thought it was mainly Bloods, Crips, and some Latino gangs.
In the feds, they killing people. And Lil Durk, one of those names that people will probably try to kill him for getting Lil Durk locked up.
I agree.
Lil Durk money too long to be. You see?
That could be the case, yes. It
by
could
him
be.
understanding that, by his attorney understanding that he could potentially lose his life or get harmed because he has moved, because he has jumped on the other side and now he's working for the prosecution.
I mean, yeah, of course, that could be the case. But it also could be the case that, first of all, from what I read, he's not in PC. Even if he was, there could be multiple reasons for that. He could be in PC just because people know who he is and know who he's connected to, and they trying to extort him, trying to get him to pay, trying to take his tray, all kinds of shit, right? That could have been the reason he went to PC. You got to remember, Durk is not in PC, but I guarantee Durk is being protected by the Muslims. Now, as far as Didi and whoever else, come on, man, they hardened. They done been through this before. Vonni, not a gang member that we know of. No record that we know of. He might be a little soft. Maybe. And people, some of y'all know when you hit them county jails, some people will if you a little soft, some people will pick up on that right away and be trying to extort you. You feel me? My first time in county, if I don't know you, or if I'm not doing this, whatever, I'm quiet. I'm very quiet. my first time in county, some people were mistaking that for being soft. But there was a dude that I went to school with already in the same pod. And when he seen me in there, he made the announcement because he was running the pod. For real. He made the announcement. Like, yeah, nah, I know him. Y'all go ahead and test him if you want to. Go ahead, try him. He'll fight you. Cause I will. At that time, I was young. I was in my 30s, early 30s at that. Yeah, I'll fight you. Even now that I'm in my 40s, if I gotta protect myself, I will fight you. You feel me? I'm gonna protect myself at all costs. Point blank, period. But there are people that have never been through this situation, like Vonni and some of these other kids out here that have never been through this situation and don't know how to handle themselves or conduct themselves amongst some of these more hardened criminals in the county jail, especially in this federal jail that they're locked up in.
Hey man, we got to file a protective order to protect your life while you up in here. Yeah, we got to protect you because we can't have you getting killed while you up in there. You are a valuable piece of evidence to this case. You are a valuable eyewitness to this case.
Now, I do agree if Vonni did flip, because let's be honest. They want Durk. They want Durk. Why y'all think them charges down in Atlanta just magically disappeared? Hell, I was under the belief that he probably put it on Vaughn, everything on Vaughn after Vaughn passed. But nah, I bet you them feds reached out. Hey, drop them charges. We got it. Not even drop the charges. We got it. Just ship them over here. We got it. We got him. Yeah, we putting a case together on him because we've been known for years that a RICO was coming for OTF. Hell, I'm a lame ass fucking dude. I don't even be in the streets, bro. And I've been saying for years, hey, because I'm a Durk fan. Hey, Durk got to stop. He got to get that other foot out the streets, bro. He got to stop doing what he doing. I've been saying that. And like I said, I don't be in the streets. I go to work, come home to my family, do YouTube, go to school, all kinds of shit, but not the streets. You feel me?
So you need to be protected at all costs. Now, understand that, a defense attorney is a defense attorney. So, of course, in the motion, he's going to put it in there real slick and say, yeah, we're trying to preserve the evidence and all that and all. But because look, cuz done fucked around, excuse my language, and done folded. He's cooperating.
I don't think so.
He in there doing this right here. And I remember in my first video, I said, like, the stuff that they know about what's going on in this case it's almost like somebody is sitting right there telling them everything.
I can explain that.
You know what I'm saying? It just seems like it's not like, the feds is guessing about stuff and they think, it appears that,
I can explain it.
This what happened. We know they did this. We know what type of cars they had. We know it's just so much stuff that they connected. I'm like, it had to be somebody that's in the inside giving them the inside scoop. And that's what it appears like. I'm talking about, like, man, I don't want to believe it. I hope I'm wrong. I'm being 100 with y'all. I don't want to believe. I hope I'm wrong.
All right, so check it out. He made some good points. Yes, he did. But when it comes to the actual facts and the paperwork, he was wrong on a lot of it. Look, I'm going to show y'all right now. I have the actual paperwork right here. You notice right here highlighted in blue. My mouse wants to act right. Come on. United States plaintiff. No, I'm sorry. United States of America, plaintiff versus Kayvon London Grant, defendant. This is his paperwork for December 4th. And it's going in, it's talking about the government's discovery. In this case, relates to defendants. Now, this motion was filed by the government, not the defense. As you can see right here in paragraph 2, highlighted in blue, it starts to go into the reasons for a protective order. For discovery, it's necessary that the government can produce the defense. You know what? You guys know what? I don't feel like reading this. I'm lazy. I don't feel like reading this. So, I got a special guest reader for y'all who is going to read through all this paperwork for you guys real quick. Just so you guys can get the real and understand what is being said in this paperwork and what is going on in this paperwork. Like I said, I am not 100% convinced that this means that Vonni is cooperating yet. Let's put it that way.
Now that we got the BS out of the way, let's look at the real stuff. You feel me? United States Attorney Mac E. Jenkins, Assistant United States Attorney's Chief Criminal Division, Ian V. Yaniela, I don't know how to say cuz name, Daniel Weiner, Assistant United States Attorneys. Now, let's just read this. I don't even want to do none of the BS that they was doing. Plaintiff, United States of America, by and through its Counsel of Record, the United States Attorney for the Central District of California, and Assistant United States Attorneys Ian V. and Gregory W. and Daniel H. and Defendant Kayvon London Grant, defended by and through his Counsel of Record Peter C. Collectively, the parties, for the reasons set forth below, request that the court enter the proposed protective order. The protective order governing the use and dissemination of one, personal identifying information, PII, of real persons pursuant to Federal Rule of Criminal Procedure, Rule 16, D1, 2, medical or health information, 3, material that may contain information within the scope of the Privacy Act, and 4, information related to protected witnesses who may testify at trial.
I'm gonna be right back. I'm gonna let him keep reading this for y'all. In case y'all ain't recognize the voice, that's Ceddy Nash. I'm gonna go refill my drink. Y'all go ahead and listen.
Introduction and grounds for protective order. 1. The government represents that based on its understanding of discovery, in this case, a protective order is necessary in this case. The government incorporates the allegations of the first superseding indictment into its representation that the discovery requires a protective order in this case. Based on the allegations in the first superseding indictment and the government's understanding of discovery, in this case, the government alleges that there are significant safety concerns regarding disclosure of names and personal identifying information of victims, witnesses, and defendants themselves in this matter. Discovery in this matter contains the following types of information: digital devices searched by warrant or consent. In many cases, defendants will receive digital data from devices that did not belong to them. To protect the privacy of the owners of the digital devices, including witnesses, the digital devices or digital data should not be provided to defendants other than for review in the presence of a member of the defense team. Autopsy-related documents, including medical records and graphic photos, including of violent crime victims. The medical information at issue may also be subject to various federal laws protecting the privacy of medical records, including provisions of the Privacy Act, 5 U.S.C. 552A, provisions of the 45 CFR 1.
All right, so are you guys getting what they're actually filing a protective order for yet? It's actually for information, right? They don't want certain people to have access to certain information.
64-102-164.
And the only reason it's coming out during his hearing is because he was the first one to go to court, which is kind of a little suspicious to me. Like, why is he making court appearances without his co-defendant? I've never had a co-defendant on any case that I've been involved with. So if anybody watching, if you've had co-defendants on cases, put it down in the comment section. Is it common for co-defendants to go to court separately? Because I always thought most of the time co-defendants went to court together, unless for some reason they separated the charges. Am I saying that right? Maybe not. But yeah, you guys let me know about that down in the comment section.
534 and other provisions of 42 USC 1306 to protect the privacy interests implicated by these photographs and medical records. These should not be provided to defendants other than for review in the presence of a member of the defense team. Audio/video recordings, written summaries of statements, and transcripts of statements made by witnesses to
hit that motherfucking like button.
And victims of violent events, including murder. Such documents and recordings often contain the personal identifying information of protected witnesses, and unrestricted release of such items would endanger the safety of those individuals. Audio/video recordings, written summaries of statements, and transcripts of any statements made by defendants to law enforcement. Such documents and recordings will reveal which, if any, defendants have spoken to law enforcement at any time and will endanger those defendants' safety. Surveillance videos of violent events, including murder, and law enforcement reports about such events to protect the legitimate privacy interests of the victims and prevent the use of such items for intimidation purposes. These should not be provided to defendants other than for review in the presence of a member of the defense team. To ensure that information concerning victims, witnesses, and defendants is not disseminated or used by persons who might to intimidate or harm victims, witnesses, or defendants, and also to do so in a manner that ensures defendants' rights to prepare an effective defense. The parties respectfully request entry of a protective order for discovery in this case. Federal Rule of Criminal Procedure 16D1 provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief. A protective order is appropriate where there is reason to believe that a witness would be subject to physical or economic harm if his identity is revealed. See Fed R. Crim P. 16 Advisory Committee notes to 1974 amendments.
So basically what they're saying right now, they want to protect the identity of their witnesses for intimidation reasons or payoff, financial reasons, whatever the case is. They're trying to protect the identity of their witnesses. How are they going to do that? It's going to get into that here in a little bit. Just keep watching. I'm telling you, watch until the end. This is real interesting.
Determining whether a protective order is appropriate, courts consider such factors as the safety of a witness and others and the danger of witness intimidation. See Fed R. Crim P. 16 Advisory Committee's notes to 1966 amendments. The government asserts that the record demonstrates good cause to permit the court to exercise its discretion to restrict discovery and inspection of information concerning victims, witnesses, and defendants in this case, as further described below, and to grant such relief as is necessary to ensure the confidentiality of that information. A protective order is also necessary because the government intends to produce to the defense materials containing third parties, PII. The government believes that disclosure of this information without limitation risks the privacy and security of the information legitimate owners because the government has an ongoing obligation to protect third parties, PII. The government cannot produce to defendants an unredacted set of discovery containing this information without the court entering the protective order. Moreover, PII makes up a significant part of the discovery in this case, and such information itself, in many instances, has evidentiary value. If the government were to attempt to redact all this information in strict compliance with Federal Rule of Criminal Procedure 49.1, the Central District of California's local rules regarding redaction, and the privacy policy of the United States Judicial Conference, the defense would receive a set of discovery that would be highly confusing and difficult to understand, and it would be challenging for defense counsel to adequately evaluate the case, provide advice to defendant, or prepare for trial. An order is also necessary because...
So you see, instead of sending, okay, let's rewind real quick. You guys got to remember, Lil Durk is going for his speedy trial. In case you guys don't understand this, everybody is automatically entitled to a speedy trial unless you waive that speedy trial. Lil Durk did not waive his. which means they had 60 days. Now, I could be wrong on this. I'm not a legal expert. I could be wrong on this. But they had 60 days from the time he was arraigned in California to bring him to trial, which means his trial is going to be in January. Right? So his defense team has to get this discovery information. There's certain information that they want his defense team to have, but don't want him to have free access to. You get what I'm saying? Like, he can have access to it, but he can't have free access to it. He gonna go ahead and expand on that, on what I mean by that.
Because the government intends to produce to the defense materials that may contain information within the scope of a Privacy Act 5 U.S.C. 552A Privacy Act information to the extent that these materials contain Privacy Act information and order is necessary to authorize disclosure pursuant to 5 U.S.C. 552A B11. The purpose of the protective order is to allow the government to comply with its discovery obligations while protecting this sensitive information from unauthorized dissemination and provide the defense with sufficient information to adequately represent the defendant. Definitions. The parties agree to the following definitions. That's where it gets real tricky. Protected witness materials include any information relating to any protected witnesses prior to history of assistance with law enforcement, prior criminal history, statements, or any other information that could be used to identify a protected witness, such as a name, image, address, date of birth, or unique personal identification number, such as a social security number, driver's license number, account number, or telephone number, or discovering containing statements made by defendants to law enforcement that were audio and/or video recorded, summarized in reports or affidavits and/or contained in transcripts. B. PII materials include any information that can be used to identify a person, including the name, address, date of birth, social security number, driver's license number, telephone number, account number, email address, or personal identification number. C. Medical materials include any individually identifiable health information that is connected to a patient's name, address, or any identifying number, such as a social security number. D. Confidential information refers to any document or information containing protected witness materials, PII materials, or medical materials that the government produces to the defense pursuant to this protective order and any copies thereof.
Okay, so basically what they're saying now, when they arrested Vonni, they got his phone. They went through his phone. There was some, I want to say, privileged or protected information in his phone, like i.e. medical records, like his personal medical records, which is covered under HIPAA. The defense don't need to see that. Lil Durk don't need to see that. The rest of the co-defendants don't need to see that. So they want to have that information protected. You know what I'm saying? They don't need his social security number and stuff like that. Now, the only reason that it looks like, that it looks like they're doing this to hide certain stuff just for him, he was the first one to go to court. I already said that. Now, they're probably going to do this for the rest of them too.
E. Defense team includes one defendant's counsel of record, defense counsel, other attorneys at defense counsel's law firm who may be consulted regarding case strategy in this case. 3. Defense investigators who are assisting defense counsel with this case, retained experts or potential experts, paralegals, legal assistants, and other support staff to defense counsel who are providing assistance on this case. The defense team does not include defendants, defendants' family members, or any other associates of defendants. Terms of the protective order. 13. The parties jointly request the court enter the protective order, which will permit the government to produce confidential information in a manner that preserves the privacy and security of third parties. The parties agree that the following conditions in the protective order will serve these interests. A. The government is authorized to provide defense counsel with confidential information marked with the following legend: confidential information. Contents subject to protective order. The government may put that legend on a digital medium, such as DVD or hard drive, or simply label a digital folder on a digital medium to cover the content of that digital folder. The government may also redact any PII contained in the production of confidential information. If defendant objects to a designation that material contains confidential information, the parties shall meet and confer. If the parties cannot reach an agreement regarding defendant's objection, defendant may apply to the court to have the designation removed. Defendant and the defense team agree to use the confidential information solely to prepare for any pretrial motions, plea negotiations, trial and sentencing hearing in this case, as well as any appellate and post-conviction proceedings related to this case. The defense team shall not permit anyone.
Fuck, this shit is long. No, honestly, I went through this probably about 2 or 3 times earlier today while I was at work.
Other than a defense team to have possession.
Don't tell my boss.
Possession of confidential information, including defendant, while outside the presence of the defense team, notwithstanding the paragraph above, defendant may see and review protected witness materials only in the presence of defense counsel or a designed person as defined below. And defense counsel shall ensure that defendant is never left alone with any protected witness materials. At the conclusion of any meeting with defendant at which defendant is permitted to view protected witness materials, defendant must return any protected witness materials to defense counsel, who shall take all such materials with counsel. Defendant may not take any protected witness materials out of the room in which defendant is meeting with defense counsel. At no time, under no circumstance, will any confidential information be left in the possession, custody, or control of defendant, regardless of defendant's custody status. And defense counsel wishes to enable defendant to review protected witness materials in the presence of any person on the defense team other than defense counsel. Defense counsel shall submit a letter to government counsel of record identifying that person, the designated person, and shall submit a copy of this stipulation that has been signed by that designated person. Upon receipt of those materials, if the government in its sole discretion finds the designated person acceptable prior to the designated person reviewing any protected witness materials with defendant, government counsel of record will confirm in writing that defendant is additionally allowed to review protected witness information in the presence of the designated person. I don't know why I keep messing that up.
So you guys heard it. We went through about 8 pages there. That was 8 of 13 pages, right? It sounds to me like the feds are trying to protect their information. They're trying to protect their witnesses. They're trying to protect certain information for Vonni. When Durk comes and does his little hearing, whatever. Actually, I don't even know if he's going to have another hearing before trial. But they're going to do the same for him. They're going to do the same for DD. They're going to do the same for Brown Eyes. They're going to do the same for whoever else. Because I don't remember the rest of their names right now. Hennessy. So, so I don't think that he's talking yet. But don't get me wrong. Do not get me wrong. If any of them are going to get a sweet deal out of this, it's going to be Vonni. Why? Because they want Durk. Vonni is going to tie the crime to Durk. Now, I want you guys to think about this. If Didi and I'm just gonna say Jam, and whoever other Brown Eyes and whoever were the other shooters, if they all get off and Durk, they all get off, they have Vonni dead to rights. I've already said this. They have his ass dead to rights. Why? Because they know he rented the cars that were at the crime scene, that were following Quando Rondo before the crime was committed. They have them on camera. They have them on photo. Those cars were rented to him. They have him buying the ski mask that the shooters were wearing while the rental cars were getting tinted. And that's just the evidence that we know about. Guaranteed, the feds have not released all the evidence they have. We don't know all the evidence they have. They obviously have evidence against Lil Durk. But anyways, Vonni, he would benefit the most from a deal. I'm not saying he's talking. I don't know he's talking. But from other things that I've read, this protective order could be the first step in him cooperating with the feds. It doesn't mean that he's cooperating with the feds. It's just saying that it could be the first step, because the feds filed this. They're filing this. They could be protecting him, or there could be a multiple reasons while they're filing this. It doesn't mean that he's cooperating, even though it would probably be in his best interest to just go ahead and give up whoever told him to do this, because they have him painted as the mastermind right now. You know what I'm saying? They have Durk. They have Durk. Actually, if you go ahead and keep reading into this paperwork, they have Durk as the kingpin. But Vonni masterminded. It's still looking a little tough for, if you ask me, it's still looking a little tough for Durk, but I don't think Vonni is snitching. I do think Jam what is and has been cooperating, because you cannot find him on the internet at all. Even his past stuff. I could not find his past stuff. They took all his stuff off. Even his past convictions. Took it off. Which probably means he's in PC with SEC. You feel me? Anyways, guys, we running long on this video. I hope you guys stayed with me throughout this whole thing right here. I hope we changed a couple of your guys' minds. Let you guys listen. Honestly, I'm still sitting on the fence. I'm not 100% sure. Somebody is talking. Somebody, and honestly, I'm pretty sure Jam's one of them. There's more than one, in case y'all didn't catch that. They were saying witnesses, plural. They got these guys. Somehow, some way, they got them. We don't know all the evidence. We're gonna wait for the trial to happen. And Mickey Truth said she's planning on being there in person. I'm pretty sure she will report on what she can while she's there. There's going to be a couple other people probably trying to pop up there. You know what I'm saying? We got that one guy that was always at the Tory Lanez trial in LA. I'm pretty sure he's going to be the one attorney dude. Anyways, so if you guys made it this far, you new to the channel, make sure you go down and hit that subscribe button. Man, excuse me. The Hennessy, boy. You guys know I'm usually a vodka Belvedere drinker. Wifey got me drinking Hennessy. I think she's trying to do something strange tonight. I don't know. Anyways, if you're new to the channel, make sure you guys go ahead and hit that subscribe button. Make sure you hit the bell icon. That way YouTube notifies you every time I drop a new video. Hey, you guys, hit the motherfucking like button. I'm a little sauced up right now. I'm in rare form. This was a good video. Hit that like button. Get this video out into the YouTube algorithm. Hey, drop a comment. Talk some shit. Talk some shit down in the comment section. We can talk some shit down there, right? Come on, let's go. It's your boy King Charm. I'm gonna finish my drink and probably go play with wifey for a little bit. I'm out.